Hello, hello, hello. Good afternoon, good morning, good evening. Any part you want to in the world. This is Mohammed Shilan coming to you from North Carolina, USA. I get me able co-host uh, for today, Mr. Jallo Jamburia from Norway. So with the talk, we'll get a few topics we'll get for talk on today. Today is Sunday, July 7th, 2024. Sorry, we're coming to a little later than we normally would or we normally can come on. Um, so we hope we will get the participation and the attention we normally can give we for this type for let we see for transmit back home to the officials then what people are concerned about, what people they want for know, and what they think say government for to do from time to time. So some of the topics we'll go talk about today, like the tripartite issue, because the tripartite was a very highly anticipated uh, issue we feel say will solve all the political problem. But of course, it doesn't turn out that way. And then because it gets a lot for do with that. But we will talk about the tripartite. We will talk a little bit about the MCC compound, the compact, the electrical um, generator where they get for bill for Win Australian to the tune of about $480 million. We for help for boost to the economy and which we understand the system will entail, roughly about how long it will take. And then I think that MCC compact they tie up with the tripartite because for the money for the release, it appears as if certain conditions or certain recommendations of the tripartite has to be met or have to be met. They will have to be met by the government or the Australian government, so to speak. So we'll go touch on that. But before we get to that, because those will be the main topics, really. But before we get to that, we can always look for touch on simple things then, or things that we'll consider important, maybe not necessarily simple. And one of which we want for talk about, now, Salon then just put a bill, then just pass a bill in a parliament. 65 members of parliament vote for the bill, 38 vote against. But then pass this bill, where this bill supposed for eliminate or do away with jury trial, particularly in criminal proceedings. So instead of being tried by a jury of your peers, Parliament tried to abolish the system without, as far as I know, replacing it with any proven alternative, but the system for just proceed without any tested policy or idea or methodology or method, we will show say replacing the jury system because most countries they might even try what you will call a pilot program. Pilot program meaning then go try say na some nice jurisdiction say in Freetown or in Bow or Kenema say okay we'll go set a special kind of system within the system. We'll try for see how efficient, how workable it is, and if it is good, and if we reach the general conclusion that it's good for the country, then we'll go try for implement them on a national scale. But we will talk for abolish a system we would get from day one, where the which man they establish a legal system for we. A system we don't get since Sierra Leone became uh, a crown colony. A system we don't get because now we own system of legal proceedings down there. So all of a sudden, members of parliament, some of whom may not have even been born, uh, even right after independence, now go ahead and vote and say abolish the jury trial. So we just want to talk about that for see how good it is, how bad it is, how risky it is. Because we think say, or for be very careful, particularly when they remove a law, and what we want to find out what are the purpose behind that law. There. Why? Why do they feel it so necessary? So we just want to talk about that. But before we go that far, and before I make my co-host introduce himself, and we'll start the program really rolling, I just want to forgive on a certain contact information. We mostly in a telephone numbers. So as usual, we always announce the numbers that we will reach with just in case. you know. So, and then, of course, let me remind people again, say this is a VOS uh, network television or television network. So, if you go from North America and you know what it cost you, you want for make the call free of charge, or get what you call toll free, and that toll free number there, if you did in North America, meaning Canada, the United States, and Mexico, you not get for pay you your money for call in, because again, let me remind you, this show is a live show. As I talk to you, so people from all over the world we tune in, go hear me. But more than that, an interactive show in the sense that you will tune in, get the opportunity for call, for sending comments, for say you piece, and we'll go broadcast that live, just like I'm in the talk show. We wait to hear me. So you so be free to call and ask questions, but not only questions, for add your own ideas, suggestions, or express your opinion on certain issues. So we want to let people know that one day. For say you can be heard live for on any topic you call about. You also can send in written comments. You don't have to call in. And when you send the comments in, we can always try for read some of them. And if chance permits, we will try for answer some of them. You know, with respect to the telephone call them, we always get what you call 3 minute limit. 3 minutes limit because we want for give chance and we don't want to let people then hold, they on hold too long. All right. So the toll free number, if you're calling from Mexico, Canada, or the United States, is 861-866-944-7722. 866-944-7722. If you call from England, there is also an easy access free number where you can get for call all the way now from where this program originates in the United States. And that number will be plus 44 2080891455. Plus 44 2080891455. Likewise, if you call from Australia, same principle at no cost, but you can call in. You get plus 61 2909 84337. Plus 61 2909 84337. Then we also get the universal line, meaning, and no matter which part of the world it is, Sierra Leone, Turkey, Alaska, Siberia. If you listen to this program and you want to make any contribution by way of ideas or expression, then you can call the WhatsApp line, which is 1-343-997-5828. 1-343-997-5828. In addition to that, we also get a radio station specifically for people over there, for right now, for people over there, Freetown. In the foreseeable future, our radio station then for serve the whole of Sierra Leone. So Sierra Leoneans will get access for listening to what in the happen. But for right now, you can only catch that radio station in a Freetown or in the Freetown area, in the western area mostly. So the number, the radio station is 91.9 FM, 91.9 FM. We encourage you for download the Google, go to the Google Play Store and the Apple Store for download the VOS television mobile app. You know, going at the Apple or the Google Play Store on your phone and try for download the app on the VOS mobile app. Okay, so we strongly encourage you now for do that. Of course, in addition to that, we're carried on YouTube or carried on Facebook. So when I go also see with it, if you don't know, if you don't get time for sitting before your computer, if you don't get time for what you see with on your telephone, you'll be able to see it at your leisure time from the comfort of your living room. You will see it on a television. So I just want to let people know that. So just in case, I also like to remind the listeners and the audience that the lines are open as soon as we begin for take certain positions or make certain expressions or talk about a certain topic. If you disagree, if you get anything where you want to what you say, uh, please feel free to call in or to send in your comments. That said, let me pass it over to Mr. Jamboria, who will make an opening statement and then talk about issues that we may want to deal with. He will be the lead man on the MCC and the tripartite, and I will be a, playing a supporting role in that respect. But that said, Mr. Jamboria, to you, sir.
Yes, thank you very much. I hope safe Rumble and they remain loud and clear. Rumble una kushe, una adu, una good morning, una good evening, good afternoon, whatever una day. I don't come back today. This is not a job we are being paid for, but we dey do am for God and country. A lot of things don't they go wrong in our country, and it's of great concern for some of we because we no wan pass through this earth, we left a confused country. We want if we die sef law go, we lay down our grave them peacefully. But the way we see things they go, it don't give some of we the reason for belief say the problem we get necessarily not to tribalism, not to politics, na simple understanding of issues na the problem. Wetin dem call enlightenment, the ability for understand something and take decisions. We believe say na that na the problem. So any of them topics here we dey get for discuss, now in that light we dey look am. How we go help for make we understand what you need for understand. Because since they be in other country, they say, hey, look Senegal, look Kenya. Yes, those people act that way because they understand things differently. We in our own country, it's like we talk, but nobody comes with solution because we don't understand things. So by the grace of God, we don't reach Sona Salon, we not go tire. Even the religion, the holy with the worship, then tell we say go in search of knowledge. So we get for try for make the people of Sierra Leone begin get knowledge. When we people then get knowledge, we go able to live peacefully, we go able to respect each other, we go able to interact. We go come out of 19 say pass we go make tripartite for can solve election problem. We go come out of say pass tripartite B before we get money from MCC. Sometimes we go reach the stage where we not even need MCC if we get the correct knowledge. It may take time, but by the grace of God, we dey come na den forum here for can discuss, for make people then know. We no dey say wetin we dey say na incorrect in totality, but we dey say wetin we dey can say na ya na for instigate una let una begin think, let una begin research, let una begin find out, let una begin see the other side of the coin. And I believe say if we begin reach that stage then dey, a lot of problems then go solve naturally. But if we not able to begin that for reach that stage, well, we go dey get all the laws them go dey to our advantage. We go dey get all the undemocratic things then they happen. Because when people are in the dark, they do things that are unbecoming. But when there is light, we are guided. Everybody they think say, if I do this thing, I go affect me, come be mortal man. I go can affect me back tomorrow. Even in we local languages, them then get them parable then they. The men they then get parable say, oh chief bell full night they make law. But tomorrow the law they catch 'em. Not also Mr. Shilon. Then you know remember that parable. They got a parable. If chief make law way bell full, that means say do am at the time when you not get knowledge. And we don't want all send the chief for the make law, then the law can't catch 'em. So law begin make now, let the law not catch 'em again. Now left this cycle of going round and round and round. Now that's not the reason you make some of within our social media. Not to for car oppose person, not to for car oppose government, not to for car instigate trouble, but now for can throw light. Let people then begin see what in they need for see, so that they go take good decisions, even to the one that we see on our government. But could they then they take decisions because then they do them in the dark. Let's just let them listen. We encourage them, let them listen to we. Let them begin see the other side of the coin. Sierra Leone, as una say, it belongs to we all. And Sierra Leone big pass we all. Now that una put on the tripartite document. Saying is good, doing is better. So now begin to announce Sierra Leone big pass we all. Do ya? Ade beguna. Mainu, lemungoy, now begin do am. Now begin do am. And if una not do am, some of you go talk, una not able to stop, we go talk. We go take una pass una do am. So na ready because say mama no dey sleep, self no dey sleep when it come. As for reach day, I go give back to my host, Mr. Shilon. You are muted. You are muted, Mr. Shilon.
So we go start with the small things. Then where I say we go begin. We go start with the small things that I mentioned earlier. Say that we go start, and then we go start with, and the minor topics. Then one topic we want for discuss, or where I think is of importance. Maybe even people. This is the interesting thing about Sierra Leone. When I was growing up, in Sierra Leone, and I grew up mostly in Minde land, as far out there at the boundary of the Liberian Sierra Leone Guinea boundary, Kailaun district, where I grew up most of my life, or where I grew up, make I talk the Creole a little better. I think say people them for understand, for say what would they talk about the legal system in Sierra Leone during my own time, during my own school time. Uh, lawyers were only the existence of lawyers was only in Freetown. There were some residential lawyers. Them I can name them: Nabo, James Iman Mahoney, Abu Kamara.
Yeah.
Before me, the left, you began Michael, Lalib Michael. We come. The latest, then, because you began people like Estin Navo, then Abo, but he was not a practitioner because I think he was a high court judge, as far as I know. But you just get a handful of lawyers. There was a time in Bo
I
when
think Charles Maguire
Batamiko,
have been there Bo at one time.
that must have been after middle left. But in the 60s,
Okay.
uh,
Yeah,
Charles was in
sometime
there.
around the 70s. Sometime around the
Yeah,
70s. That was when
exactly.
he opened office in Bo.
All right. So in Bo, the entire 60s, you get Abu Kamara, Mahoney, like I say, and I cannot think of and then Michael Ali Michael come much later, maybe then 67, 66. Um, but before then,
Yeah.
there was a partnership of Bata Macaulay, T.S. Johnson. I think Abu Kamara was with they get from that partnership there. But, the prevailing law up country then, or practice, the prevailing legal practice in Sierra Leone was mostly the native administration or administrative kind of
Yeah.
law. Every side they get court barry, or who can call that's what we can call them. Every chiefdom, every small town, get where you are, get local people them where they sit down in judgment of others. Now so the which man be designed and for make and that system there was extremely efficient. Both the civil system and the criminal system. The criminal system was too efficient to the point of, but we never get guidelines, we never get guardrails in terms of protection of people and individual rights. But in those days, we don't know much about um, due process. We'll not be too conscious of human rights. We'll not be too conscious of civil rights. So, looking back at it, knowing what I know now, the criminal procedure in those towns were very swift, very effective, very harsh, and very oppressive to some extent. And then certain things that were considered criminal in nature, like if I owe you money, you know, pay me. Uh, I mean, if I owe you money and not pay you, you can go summons me. Then they can arrest me. They can go lock me up. Even before I get a hearing of whether I owe you or not. And then when they lock you up, then they get administrative things like administrative process whereby they can grant you bail. You go come out and go court. That not be exist upline. But the system was very fair. It was very efficient. It put a lot of fear in people. Then where you owe debt, you for pay. Where you do wrong, you will have to pay for it, and so on and so forth. And I'm touching on all these things because you see, the main body of laws was the Western English common law. And let me not forget, say around that time they will just imagine we will just they get into this constitutional issue in practice because we practice never just the British common law, the British common law way of doing things, the procedure and everything. Constitutional issues and constitutional rights were not part and parcel of our legal process and our legal procedure. Okay, so everything was based on the common law. You know, due process was not a big thing, even in the main body of law now, besides the upline law or the upcountry native administrative kind of law. So, but I just try for church on the development of a legal system. But even in those days, there were certain guidelines in place. And one of the main guidelines where they be put in place, where the which one they put in place, now a practice of a jury trial by your peers, trial by people of your kind. because them figures say no matter much a man, we all are fallible. We all can make mistakes. We all get biases. We all get prejudices. We all get a tendency, if we get a lot of power, we can abuse with power. There are safeguards we set up in case a judge abusing power, how you will appeal them. Okay. And now, for all these years, from the time which man they defend with country, from the time where they introduced the common law system of the country, when that with the practice, and we can't just be picking and choosing, because if people then begin to argue, say, in fact, to me, the least uh, substantive thing we get, we inherited from the British system, whether for well rig and gown, we seem for all that up high. We think we'll pull down, we want that practice, we would like to see the white wig, now we head in the gown, now we body. But yet, when it comes to making substantive changes, we want to inject politics into the whole thing. So now in Sierra Leone, they talk for abolish a jury trial. If they charge you with a crime, they want for, well, first of all, the thing I don't understand, why will any member of parliament, regardless of the party who you did, why would you even want such a system? We'll get a system that way you can get a trial by your peers. In fact, one of the things I want to find out, the lawyers, the criminal lawyers, the way they practice criminal law, they not even they apply or they use or take advantage of jury trial. A lot of them go to trial by judge alone, exposing their clients to, particularly on cases where you get political overtone. Like, for example, if you charge with a attempting to, if they charge you attempting to overthrow government, if they charge you with public riots, if they charge you with anything of that sort, it's kind of cases in way judge, we know governments, and not picking on this particular government, we know every government that has come and gone, get interest in then camp trial and day. And with any kind of a trial and day, you want to ensure maximum fairness, and maximum implementation and exercise of the law. We don't say there are certain laws, there are certain offenses, there are certain defendants in whom the government interested. They want to lock them up, they want to make sure, say, come there for a long time. Like the Kamarimba kind of case. Okay? All right. So, but surprisingly, lawyers in Sierra Leone not seem for all this jury trial as such an effective tool for ensure fairness and for ensure the likelihood of your clients prevailing on, a trial. So what you can do? I mean, a lot of lawyers and the waive, and they're like in the United States, a jury trial is a constitutional right. Nobody get the power for waiver unless or except you, the person who is on trial. It's a guaranteed right. The government cannot waive them for you. Your lawyer cannot waive it for you. And if your lawyer do that, you get for express in open court that he's doing it at your behest, that you tell and say for do that. And usually they will make you sign something to make part of the court record that you knowingly, willingly, intelligently waive your rights to a jury trial. Now, we do have trial by judge alone, criminal trial, but only if you choose to say, I want to be tried, I don't want a jury trial, I rather for be tried. And normally, that is determined only when lawyers make a determination, and they will recommend that to the client, when they make a determination for, say, the nature of the case at hand is such that they get a higher chance of winning on legal grounds, with legal arguments, mostly without getting into a factual situation or not the basis of the evidence, the factual evidence, but basis on what the law or how the law is. So some law sometimes people can exercise that right. They say, at the recommendation of the lawyer, say, okay, I go rather choose waive my constitutional right, which hardly ever people do now, but it happens. Then go waive their right, then we'll go then can use just the law as their own right or as the exercise of the right for go to trial. But you know, they see that common. Like we on system now back home, we know say government at openly sometimes can get hands in it. Like the Palo Conte trial. How do people think Palo Conte will have prevailed if it was in a jury trial? It was obvious that when Palo Conte was found not guilty of what he was being charged, except the gun violation, the government wasn't pleased about it. And then, in fact, the government ended up sacking the attorney general because of the loss of that case. You see, so Paulo Conte will have been serving long time still in jail had he waived jury trial, no question about it. And what surprised me was not that he had a jury trial, but the courage of the jury and to have come back with a not guilty verdict on some of the heavy charges they wanted to bring without fear of retribution or without fear of being, what we can say back home, well, you're not afraid to say government will put you up at you. Now, that system there will try to ensure that you will get your day in court, that the government not going to put in thumb on any kind of case. But now, the trouble with that system there now, and I see other people like Kamarimba did not have a jury trial. I think he or a lawyer decides say, I will not waive a jury trial for anything in the world if my client is charged with a crime and I'm defending that client. If he's entitled to a jury trial, we're going to go for it. I rather 12 people of my client and peers listen to the factual evidence, because mostly jury trial based on facts, circumstances, and then you, of course, you the lawyer, your power of persuasion, because you can get all the facts in your favor if you're not to an effective, convincing attorney or lawyer, you may not still win. But so Paulo Conte is a classic example that he's a free man today because we had a jury trial. He went through the system, and then what happened? The system, the courageous jury came back and said, no, he's not guilty of attempting to overthrow government, which I think the government never had. It's a case the government never. They didn't have a case in that respect. They didn't have a gun violation case. But now the bill has just been passed in Sierra Leone. The only thing left is President Bio not sign it, where then say they want for get rid of the jury trial or the jury criminal, particularly because they call on the Criminal Procedure Act of 2024. So I am not sure whether that's applicable to civil matters, but I don't think civil matters then they do jury trial as much. We get jury trial now. I think that any jurisdiction of the United States on both civil and criminal matters. But criminal matters are more important in terms of because people in right and liberty are at stake. People in freedom and liberty, they're at stake. So it's a constitutionally guaranteed right, a jury trial. You are guaranteed that unless you knowingly, it's not enough to waive it. You for knowingly waive that right today, because even when you waive and judges are hesitant, the judge will bring you in a court and examine you and ask you all sorts of questions from if you're under the influence of drug, alcohol, or any intoxicating substance, to have you been threatened or promised anything in exchange for you waiving your right. The court wants all of that on record because it's of such vital interest to the system that they don't want from it. They're not taken very lightly. And so here it's a thing where we inherit one a part and parcel, not only of the Magna Carta, the genesis of the British common law and British and legal system, what we inherit. But now we say we don't want that. So the question is why? And we also know, say, we system get a lot of fixing where it need, a lot of corrections to be made, and we put at procedure. I mean, in criminal procedure and civil procedure, a lot of things, a lot of work has to be done for improve the system, both criminally and civilly. So, number one, I wonder why all of a sudden, well, it's not all of a sudden, let me take that back. Why, in the scale of preference, why the abolition of the civil, I mean, something where they guarantee people fair trial? Whoever thinks is of such threat to the system that it needs to be abolished, to be gotten rid of. I'm really concerned. I'm really interested in. I would love lawyers who may be listening, or someone who may be listening who will try for replay this recording to any lawyer, particularly parliamentarians or people in the position of authority back home, we will call and make a persuasive case that it is necessary, to even put that on the scale of preference of things we will get for doing at the country, that the jury trial, when at the bedrock of a system, that's Sierra Leone, when I ensure everybody optimum protection, that people and things say is feasible for abolish the law. I mean, for abolish that practice day. Now, President Biono signed a it. For people who may be interested, I think when I need for calling a parliamentarians them, or calling a lawyer them back home, ask them why they think such a thing is important. That the president, if possible, not for sign that bill, because it will come back to haunt the president's union loved one, unless the president is going to be president for life. But if you make the law such that you eradicate a jury trial, your loved one or anybody within your own distant or immediate family may get caught up in that system there. Because one of the worst things we can do now for make laws with political motive behind it. Just because this law where they talk about so, what you mean no? Even though now the current parliament pass them, but this is an idea that has been contemplated as far back as the Anes Kuruma regime. That's a doubt, without a doubt. I know that firsthand. The elimination of this jury trial in criminal cases was contemplated maybe even before, but it was being actively considered during the Anes Kuruma regime. I know that as a fact. It's not rumored, because I talked with certain authority who said they were thinking about abolishing it. And when I ask why, I want to tell them, say, I think it's a slippery slope. They shouldn't even think of that. I was told that, well, we literacy rate too high, and that they so going to courts and will not get the sophisticated jury our jurors them among the general public, where we go listen to cases in an understanding way for come up with a just decision. I take issue respectfully then with the official who made mention of that to me, and this was a very powerful person in the Anes Kuruma government. I think that's dangerous. I say because why are we even concerned about high rate of illiteracy? The tell me the which man they introduce the jury trial system in Australia. who probably had about 95% illiteracy in the country. But they saw the wisdom in implementing a process and a procedure whereby you can be tried by your peers, particularly when your freedom and your liberty they are at stake. It's not a white matter now. So this is what we have to be talking about. We want to talk bad about them white people here. Then create a system where them figure say them for protect your rights. We cannot we not to replace them with anything with an alternative. We just can we abolish them, we get with reason, you know. And then I even have a friend who says, well, the native administration or the native system not get uh, jury trial. So we may not be missing anything. Some people just say, well, jurors then go take bribe. Well, all of that is just being intellectually lazy. Because if all them points then they would raise, if we think say these are foreseeable and preventable problem, now that may God make we get brains, and that will make we get educated, we go school, we implement laws and implement practices who will combat the anticipated type of shortcomings them. Yeah. If we think say jurors then will take bribe, I mean, a juror can take bribe in England, Australia, and yeah, if they want to, if they never get a system in place whereby if you do that, you know the level of risk where you take. So instead of we for put your mind to work and try for find solution, we just make it easy by just eradicating certain things we know how to deal with. You see? So this is now one of the things then where me, I just want to let people in try to explain to we. Tell we why jury trial is so bad to the system that when I get the need, with all the problems with the legal system get, with all the corrections what the legal system need for improve, speedy trial, case to take 10 years in our court system, will not seem bothered by that. Prisoners are locked up, sleeping on top of each other, eating food once or twice, once a day mostly. We're not seem bothered by that. Court procedures. A person constitutionally is even wrong for sometimes a defendant is referred to as the prisoner in the dock. How does that you juxtapose that with the presumption of innocence? Why should someone be called a prisoner or be presumed to be a prisoner when he's on trial and is presumed to be innocent of the crime for which he's charged, but already he's been referred to as prisoner? You look at the procedure, you look at the court system, you are being put in what we call a dock, like a cage, although not a cage, but then put you on that bench, very uncomfortable bench where you get for sit down, you get trial for a long time, all day you just get for sit down on that hard bench day, then they lock you up and then put you in this dock, then call them. When are they you sit down? You know, they even participate in your own defense if you're not defendant, because your lawyer gets you in place where they sit down. Unlike here, because a defendant should be able to participate in his own defense. In practice, you are not even able to whisper at your lawyer and yes, because you there under your lawyer in there under you see all of engineering now we need for fix. Now, people, that ideas and then it will come to people because of who-sided study. If everybody study law in a salon, we'll not get the most sophisticated system, a salon, and there's a total lack of interest in the set of people that will get the power for improve the system. They're definitely not interested in improving the system. What they're interested in doing is coming to a country like America, a country like Canada, Australia, England, getting diplomas for go put on the wall for say, well, I get this diploma from Harvard, I get them from Georgetown, I get them from Cambridge, I get them from University of Aberdeen, I get them from University of Calgary. Then Trinity. Okay? Now we're not interested in going back and building structures, the courtrooms that look like the kind of courtrooms they will get now. They're not interested in building facilities, for um, participate in a smooth process, of criminal justice. We folks them when they come abroad, they are not interested in any of that. You know, what all they are interested in are for go show off with paper. That's why we're not to make much improvement. So again, this is something when I hear it, but I say this is dangerous. If they allow the jury trial system to be abolished, it could be one of the worst things with people and one of the worst disservice we don't do to we serve and to we ordinary people them since independence because it's just absolutely wrong, completely wrong because it's very, very dangerous. You know? So the act, like I say, and the parliament of pass them, President Bio just the try for then want let President Bio sign them, uh, but it's dangerous, you know. It's dangerous, and we will think about that. So, like I said earlier, there were 65 people who voted in favor parliamentarians, and then 38 we say we vote against. And it's a significant change in our justice system. If we go make significant change in our justice system, I just wonder. And then, with respect to the recommendation by the tripartite, shouldn't that have even been for make such a change or a change of this magnitude? They should have tried to do that with some sort of, I would say, the best thing I think they could have done would for make a referendum of some sort. But they should not have made it this kind of rush thing. People are going to parliament. The idea has been lingering around for a while, even before President Bio kind of power. So I don't think it's anything new to them. But not forget, say we get a system whereby a lot of times, because we see that happen with Shaka Stevens and Sir Albert Magai. Sir Albert Magai had all kind of weird ideas as to what he was going to do after the 67 election. How for make a one-party system, how for do this, how for we get presidential, for they don't want, and for Una, we don't know. When we first get to independence, the prime minister will be it. So Sir Albert was the prime minister. Shaka Stevens started off as a prime minister. We not be get a presidential system. Now, corrupt motive now in lead to the presidential system, not because they see anything good. We forget the president. Pashaki just not be want for be accountable to a governor general. When I be forbid the ceremonial president, because this is the system where we inherit now with legal system or now we country or political system that Israel gets, that England gets, that Canada, England, that Australia gets, that Canada gets, you get powerful countries like India, one of the largest democracy. That's the system they have. The prime minister, Pakistan, and that then get, no, I think Pakistan and then get the presidential thing. But India, Australia, Canada, Israel, then get this prime ministership, and a few other countries. That's the system we go into independence with. But when Sir Albert first came, when he succeeded Sir Milton, these were all ideas he had to change to become president. Unfortunately, after they make all the laws there, he end up not kind of power. Shaka Stephen turn around and implement all of them and they for in your benefit and change the system. We are beginning to see the same thing. And then the same jury elimination or abolition or we then do so. I know as a fact this was some idea contemplated within the previous government to do. I know that as a fact. And Then now, Udaka implement them at the current parliament. And if it is signed, I mean, Udaka pass it at the current parliament. And if it is signed, it will be implemented by the BO government. Okay? So there are times when laws are made with the wrong or with a malicious intent in mind, it can boomerang and end up working against you. Now, any laws we would pass in the country, we for try for look in the best interest of the people and ourselves. Because if we care anything for our grandkindem, if we care anything about our family, and if we care anything about our country, because even if you're a foreigner, you commit a crime. I always can cite the Kurubali. Well, again, Kurubali case was a technical case. Kurubali was presumed, there was a case called Kurubali, the government of Australia versus Kurubali. I always can say, Kurubali was a diamond dealer in Bamakonta who allegedly killed a top-notch police officer then in the 60s called Grant. Grant was a high-ranking police officer. And then Kurubali, and he did it in plain view. He killed him with some iron bar, with some metal bar, where he takes strike him over and over in broad daylight in early one afternoon and kill him. Was no if about there were a bunch of witnesses. And in fact, it was so shocking to the legal community because that had never happened before that no lawyer was willing to represent Mr. Kurubale, with all the famous lawyers they were Australian. Nobody was willing to represent Kurubale because he was being presented to the public as a foreigner. They say he was a Gambian. He was not Australian. And that this foreigner, that kind of country, they can kill one of William top police officers. There was a notable lawyer by the name of T.S. Johnson. While the government was busy trying to give this man a fair trial, they said they could get a lawyer from England where the government would pay. T.S. Johnson got up and said there is no need, he will represent this man. And anybody, if you're a lawyer in Australia and you listen to me, you need to go read the Kurubali case. It was a masterpiece defense. One of the best criminal defense trial ever in the history of Australia. T.S. Johnson came out with a manslaughter verdict, even though this man killed a top-notch police officer in broad daylight. And it was a hard-fought trial. It was a well-publicized trial. But Kurubali was found guilty, not of murder, but of a manslaughter, and was sentenced to prison for 10 years. Okay, with that, these are some of the things we talk about. So without then kind of a safeguards them, we don't know whether in this day and age we will ever see then kind of a masterpiece, classic criminal defense of a defendant by an able lawyer, an Australian again. Maybe those opportunities are gone. It may never happen again. But there was a time when you get lawyers who knew the craft, who can go to court and do masterpiece work and do impressive work, who will protect all the rights of their clients, will not be to sell their clients to the other side. So, but with the abolition or the doing away with a jury trial, which is a major component of a democracy, we are playing with fire because it won't be long before some of the very parliamentarians who vote for him will get caught up in that against them. Or if there is a shift in government, where the same law will be used if the president were to sign it. But I will urge the president, for the good of the country, for the image of the country, not to sign that law there. Make it think about it again, because it's not a good law. It's an oppressive bill, and if it becomes law, it will be very oppressive. It will take away safeguards, privileges that we've had, and part and parcel, a component of the legal system. So I just wanted to comment on that. There is there's a criminal group, I mean, of defense, or there's a law society of people. We they call them the Institute for Legal Research. So we do raise an objection to that effect, asking the president to not to sign it. But those are the only ones. Well, this goes last but not least. This is why we were talking about the Bar Association, the election should not have had any government taint or any government involvement. Now, is the Bar Association going to raise any objection to the passing of the abolition of this, like this Institute of Legal Research? They'll do. Are they going to be able to, with the nature of the past election and the composition of the current authority or those in charge now the bar association, are they going to object to such a law? Let's wait and see. They should, but is this one of the reasons why government felt they had to put their thumb on the scale for conducting and try to make a particular person win as president of the bar association? But these are all dangerous times, because even if you're a lawyer, even if you're there on the good side of the government now, this is not going to be in perpetuity or forever. There will come a time when power will shift, you know? So with the talk, and it's a disservice to the country when you get a group of lawyers way for no better than one for be part and parcel of just chipping away the institutions that we will get in the country, you know? Because of all the things that we will get for doing Australia, me not even know why parliamentarians and people say elimination of the jury trial is of such importance. What harm is going to be done if it's in place? And what harm has it been for it to be in place? So, me not understand. I don't know, but we are embarking on a slippery slope, and it's dangerous. So I think as a lawyer, why I read something like that, and they say reasonable men can differ. You may get other lawyers who disagree with me, both in Australian, maybe Australian lawyers, then you get a few of them now. The United States here, we may disagree, but I think this is no way to go. We just can't make it consistently a pattern of chipping away constitutional rights. You know? So, with that said, I think I've spoken enough on the issue. So, if my co hosts get any comment to make on it, yeah. If not, we can move right to the next topic.
I think I have a lot of comments on this, Mr.
Okay,
Shillong.
let me hold you.
And
I just realized we
I go
have a couple of
implore
calls.
the callers, let them wait till I make me comment. I'm coming with something
Go
very
ahead. Go ahead.
serious.
Go ahead, sir.
We have to talk about Sierra Leone, but let us talk from an informed point of view from now on. This law has gone against Chapter 3 of our Constitution. I go implore the judiciary, let them look at Chapter 3 of the Constitution, we prescribe the recognition and protection of fundamental human rights and freedoms of the individual. Let them look at from a very technical point of view. The other point is, any international convention that has been ratified by a country automatically is applicable as law. The Human Rights, Universal Declaration Human Rights of 1948-49, Article 7 of it will be contravened by this law. You see, I would use three quotations. Martin Luther King Jr. once said, "Nothing in the world is more dangerous than sincere ignorance and contentious stupidity." It may sound harsh, but when you are in public service, The use of discretion should not qualify within that quotation. And what we see in Sierra Leone today is that most of the decisions that are being made is abuse of discretion. And some of the decisions here may protect certain vested interests as at now. But those decisions will create room for grievances and conflicts in the future will go affect the very relatives and children of them people then they. A very sound case in point. This present government took over office with a mentality of vengeance because certain things had been done in the past by the APC. Now they are creating the same room for vengeance for future generation. What does it pay a man to gain the whole world and lose his soul? If you make judgments, if you pass policies, if you make laws today that are going to affect your children tomorrow, then you've gained the world and lost your soul because your posterity is your soul that continues to exist after you. So I would advise, let them go back and review this law. When the fact that they pass this law, it brings to question the maturity of the parliament. Because for make such documents pass through a parliament, then therefore do all the research necessary for ensure say the law not a favor, but it assist society for be a better place. Because every law made is to assist society to be a better place, not to punish or to favor certain people. When you make laws that favor certain people or punish certain sectors of the society, then you are creating room for conflict. Therefore, begin bring them things out. Let people understand that. We don't talk about kunas alone, but now begin talk what thing will make people and begin think. Because one of the things I see, people and they sleep mentally, as alone. And it is show more in the people in governance. They talk and take decisions with so outlandish that you they wonder whether they think. I go end and they first let the callers come in.
All right, sir. Thank you very much. Hello, caller. What's your name and where you call from?
Yes,
And
sir. Good
feel
evening
free
again,
if
Mr.
you don't want
Shilon
to.
and
Okay,
Mr.
Mr.
Jamboya. Good
Mustafa.
evening and
Thank
thank
you
you
for.
very much.
Yes, sir.
This is for the Mustafa from Leicester. So, I mean, why I've been seeing this thing, I've been facing a joke because a lot of fake news they pass around. Because first of all, what you inform the change? You go ask yourself. Like you mentioned, say maybe it begin from the past administration. Okay, they had a thought, but then for them we formulate anything for counter and parliament for can do am. We left on that we left on that side there because they not to like I mean constitutional amendment where they start a process. This now something go just bring overnight in a parliament, they can pass them because we know parliament. You see, these people they don't think for the future, they just think for today at this moment. Even the APC, they make their new constitution, they put one clause they say if you want can join the party for contest, you get for be here for 5 years. Because they want for outclass other guys them way they don't want for let them for pay like Sam Sumana and the others. They are just thinking of today. What about if I come on here, get the resources for go put make on a party on a give on life. It will shape with a part of which kind of silly person. They are just looking for today. They know they think say I dey come here today or tomorrow how think it will be for me. Like he come back to this law with it out. The thing way is Paulo Conte. This thing now strictly for Paulo Conte freedom. We that freedom we get. You know, say remember, Cameroon say we ask for zero trial, they say they don't go do am. Because then for why I read the thing on the internet, they say outdated law. Nothing they put am more. So it means when they practice in America and UK on outdated law, that is how they presented the idea. They said it's outdated law, so they count a better law. Because they don't say the lawyers them, the judges and as alone. When a government appoint them, anybody when they say they charge them for this crime, then they charge. I always refer to Kamarimba in trial,
Mhm.
LEJ in
Mhm.
trial.
Mhm.
These are trials where you convict person from here say that person say the other person say no, not so I do. You say that the judge say that's what you do. This is not the way you convict somebody. And the same judiciary, we then don't like the government, we don't try for anybody we then put through that intimidation, it will succumb. Now
Of course.
LJ they
Of
can't talk
course.
say he tell God thank you, tell Madam you thank you, free am. First of all, you have to ask yourself, who that put you there? You just said the United States they say not give money. So if they can't put these lawyers to say a juror trial, if I come out because I outdated, me, I'm like I don't. You see, like how soon they talk about saloon, like now motoka we then start, but then put on reverse gear. Now be no way they go. I was a small boy,
Indeed.
young man by then. We the NPC come. Now I hear say, trust like papa. If you be a teacher, now he stop for teaching now. Then get motoka. Then I shock as you. I say, why this man for stop for teaching now? That's a teacher. Let continue job. Which my friends they ask me, they say, hey, you want to say today if you be president, papa will continue to teach. I say, yes, that's the duty. Now in profession, Dandy. Why if you come out there, if you go buy bills for them, do this for them? Because that's all they think. That's all they think. Today, these people, this law, when they make so, when they say, then they abolish you. Tomorrow, them go be the victims who they cry for say, oh, I not do am, I not do am, not so I do. Then you stand there, then we tell you the Kuti piece they cry for now, they talk say, oh, you sack some tomorrow. And then you have nothing to say because this is what you did. These are your actions. So I just the things I just dey talk say we country, I don't know which we go talk again because these things we are saying these things all the time. Nobody's listening. They just they focus on one thing. Like where they sit down a corner, then they watch people they do things them. Now they don't come say, oh, what they be doing? We can't turn and give una. And now 10 times so. Is that governance? Governance where they say politics. Now for can improve people their lives or you maintain their living standards. Not for can put them behind. And these things the way they try for go and hammer on so they know they affect people's lives. I mean the economically. Now for just suppress people them. Anyway, I hear the buzzer. Well, thank you. Maybe I'll call back later. Thank you very much, guys.
Yeah, please call back later if you think of some more ideas. We welcome you brilliant ideas then we can come up with almost every time you call. Thank you so much for calling. Hello, caller. Please tell your name and tell which side you call from.
James, Mr. Shalom, how are you?
Yes, sir. Fine, sir. Thank you very much for calling.
How much you don't read this act with this act criminal procedure act 2024? You don't read the answer
No.
because I just did read the mode of trial. If you go to section 139, the
Mhm.
only thing they do to the jury, what they reduce am from 12 to 10. If see then and I put some on the I put a face, I put some on the what. So I don't know why they think people are just misleading that the jury trial have been banned or have been taken away from our criminal procedure act. I don't know what people are going to
Okay.
gain.
I'm reading it as you are talking. Go ahead.
Yes. If you go to the mode of trial from section 139,
Yeah.
because the only thing, the number of jurors that is not reduced from 12 previously to 10. So I don't know why
If
people.
that's all it is, okay, go ahead. Go ahead.
Yeah, now that's not a new contribution. I hope people read it before we really make big deal of it. You don't say
Okay.
anything
I
like they don't.
I don't want to think this is the essence of the entire law where you just post, because it says Sierra Leone Parliament has officially passed the Criminal Procedure Act of 2024, repealing the outdated 1965 Act. Notably, Parliament has removed jury trials from the criminal justice system, has removed jury trials from the criminal justice system. The abolition of the jury
Because you go to the
system
mode of
was,
trial. If you
so
go
that's
to
why,
the mode of trial, under section 139, the jury trial is
okay,
still alive.
Is
Cannot be
this
taken
the
away.
law that was passed? The
You're
one that
sure?
Mr.
this,
Vandy is showing us. Is it the law that was passed?
is that a new law?
Yes, yes. If you want at the upload onto NLP form, if you
Landing
go
at the
to
table for the president for sign?
yes, 129,
Okay. I don't
139.
want to think so.
If you
Well,
go to
I
trial,
don't want to think
well,
so.
in this case, Mr. Vandy, in this case, they put the blame back on the government. Laws are not secrets. They are made to help society to be a better place. When then they make them laws here, then forget time for the public discussion and debate on that. It's the responsibility of any good government for debate certain laws before then even the care and go na parliament. Let them get public input.
but
This is what they do in
you
the
might
country
not
I live, Norway.
that's not right. But I think say our members of parliament in that country, they represent every constituency, every district, which we don't consider a district as a constituency. They should go back to the people and educate them and ask them view before this thing was even passed. But
They
as
don't. They don't. If they are done it, then this misunderstanding not go there. Because what in the press publish and what in you show we, then they in contravention.
Yeah, exactly. They are opposing uh,
yeah,
things then.
so you
Because
know,
they
Don't.
say,
Don't.
yeah, and
You're right.
I
You're
think
very right. I know they argue the point,
who-
say the members of parliament for going from them people. That's correct. That's part of their duties. But they don't. So
yes,
any of them misunderstanding how
you
they
want
come, therefore carry
this
the
I
blame.
can send it to anybody who is interested because this is misinformation about our country. We have to be careful.
well, I don't
So
think it's misinformation.
people can read it. Why? I don't know why people choose to misinform.
If there is a misinformation, then it is the responsibility of the government or parliament. Let us put it that way. Because parliament is part of the
That's
government.
true.
It is
That's
their
true.
Well,
You're right.
responsibility. They cause
I'm
it.
not arguing that.
well, Mr. Vandy, I appreciate you taking the position we you take. But even if it's misinformation, it's information for the better. Because what you would argue, it protects you, it protects me, it protects everybody. This is the point we're making.
Oh,
This
you're
has
100%
nothing to do.
you're
This has
100% right.
nothing to,
That's the
you
you're
know.
trying to take away. That's one whole right taken away from the people of Australia. So all one for first one. But before me,
These
I just
rights
go
are
to
right. But the
go
fact is,
to the mode of trial.
if this thing has not been given the proper information procedure we forget, then any misinformation commodity, it is the fault of those who made the law. And more
Okay, Mr.
so,
Van,
after this misinformation on the circulate almost days, there is no official reaction. You see, now
okay,
let us take we country
Yeah.
slightly. Information, now they
But
bring peace, now they bring stability. Correct information. It's not when things go wrong we should begin to talk. We should be proactive for give correct information to people so we go save 9 stitches on time. This is one
Yeah,
of the cultures that we have to adopt in Sierra Leone if we mean
you
to
guys
make
are
Sierra
right.
Leone go before.
Well,
You know the
how
way to
every
waiting poem, all man can begin to. Let we talk am before it happen. Say this do as we
very
know, we should be alone.
things going on
They
in
are
that
not
in
big
that
pass we all.
because there is going to be community. Most of the petty crimes, there are going to be a community service and probationary period. Those are progressive law. There is a lot of things in there. That thing is even provoke me. I go look for one. I don't read one. I'm not done for it. But there is
Okay,
I see a lot of with the past.
Mr. Vandy, would you mind posting it on our Facebook chat so we can will you mind displaying it on the screen on the Facebook so we can have a Facebook chat on it? Um,
I would download and
Yeah, do that for we because all this matter, the information here, now they help we for bring stability and go forward as a people. Do that.
yeah. And
and
there's one
don't forget and do not forget with position we are simply saying if the law is what it appears to be, we are urging the president not to sign it because it's not a good law. And it's for everybody's
that's
protection.
true.
It's not got nothing to do with
That's true.
politics.
That's true. You guys are right.
Okay.
Okay. Yeah.
So now we on position now for do waiting good for we all. Not for waiting good for APC, waiting good for SFPP, because the law they know they apply the law. There is no law for APC, there is no law for SFPP, there is no law for this
They all
party.
now one
When the
family.
law takes you, it takes you. So we try to let people be informed. That's all.
They all now one family, Mr. Shilon. So if they want to make law, they cut the na the business. We na the
But me
nation we
know
concern, but
so because I know this idea of getting rid of the jury system was discussed way back then. So I know say. So, but let us see. There are other callers who
I
may
think
call
we get
somebody to
other
clarify.
callers. Them let them
Yeah,
come
but
up.
Mr. Bandy, please go ahead and help we out. Post it. We don't claim to have knowledge in everything. We get topics for discuss, and this is why we want to inform people like you for participate and call and raise your voice. So we thank you very much. Please do that and call me back if you get the time. Hello, caller. Please tell which your name and where you call from. Hello.
Shilon. Yeah, this is Abdul call from Nigeria.
Yeah, Mr. Abdul. Thanks for calling.
Yeah, I just want button in on this very important topic we already discussing on this
Jury trial.
2024 Jury Trial Procedure Act we then just pass. We all know say the criminal justice system in Sierra Leone is nothing to write home about. But from the posting when I read and from the news, because I'm able to peruse through the articles, but from the posting when I read, it seems as if it is a total abolition of both.
That's what we thought.
Yeah, because that me self this because I get to the news where all them days here say at least it's a total abolition of jury trial by all courts in Sierra Leone, and where then they go be a disservice to citizens of Sierra Leone. I don't know. I don't know whether we get an act, a jury act, we make a mandatory for citizens for take part in any trial by jury. Like how we get in the United States where it is mandatory because the so-called individual where you may talk with some time ago, where they say now because of the level of education, because of people exposure, I'm not buy that. That's not absolute bunkum. Because you get about 40 people, 40% of Sierra Leoneans are now educated, which are being way before read and write. So I don't think all that. But I don't know whether we get on our law books, we make a mandatory that if you are called for for partake in a trial by jury, then will pay you for that day when you go work, or then will compensate you. I don't know if we get some, because if you mandatory that then will pay you
I
in place
believe
of
say
work,
a day. I believe say a day. And look at the screen. They don't put something on the High Court. I
Okay.
believe say we get something where they call juror service in Sierra Leone, where mandatory. I know able place switch ordinance, but it was done during the colonial period. As a matter
But
of fact, I even know say if they call you for juror service, certain ethical standards they will for observe. If you fail, then something against the court. It did.
because
And I
because
will place a number now. Then now some ordinance. They call it ordinance. Something, something, something. You know, get a
Yeah,
lot of colonial laws them where they no
that are, that
they
are still
still
on the books.
active, but they're not they update them.
they don't enforce
That,
that.
that
Well, the enforceability of the laws, the nine worries some, because most times they read judges and they say therefore don't give a ruling on certain trials them. But because the jurors them then they absent, you get jurors the way they absent, now because of that. So but if you don't enforce them, let me can mandate for people and say this is a national service where you for do. You know, so, like who gets an aya no na the US there way. Begin fender excuse them because you know say then go pay you then go pay you now you place of work.
They get bench warrant. They get bench warrant if you're absent without reason. It was happening before in Sierra Leone.
But they are not enforcing
I
it.
know. I wonder why we don't go beyond so far that we don't forget all them things and they.
They're not the
well,
In
let me.
there, there is a law.
because when they're not the enforce them, so they make like people go they refuse because some trials then they will go take 1 month, 2 months, 3 months as it could be. But if they are enforced and say you will be paid whether private or public servants, if you are private place in the work of public, they're supposed to pay you because it is
You
something
dey
that
get you salary. I believe so. If you dey on juror service, you dey get you regular salary.
On the books, on
Even
the
if you know
books,
who na your place.
on the books, that's the way it is in Sierra Leone. In fact,
Yeah.
the law talks about if you are
I don't know the reason why people are not agree attend do or service, then go prefer for the just the because I don't think they lead to lengthy adjournment of cases. Some cases and then are 2-3 months if I don't pass judgment. But then they keep on adjourning the cases, and because then they make excuses for the jurors and say, well, the 2 jurors are absent, 3 jurors are absent, 1 juror may this. And I flimsy excuses and they give. I don't, Mr. Say don't go to court where they listen to cases when I they excuse them. If I say in 5 minutes, they don't adjourn the case. They say almost jurors, 2 jurors, 3 jurors, they absent. So that is seen and it's frustrating for litigants. So, but this particular one, let it go because the Constitution in Part 4, Section 131, where it mentioned and say, Part 2, the High Court of Justice shall be duly constituted as the case may be by any one judge thereof or by any one judge thereof and a jury. So therefore, just left and they let be all, either or. Like when Mr. Shillon rightly mentioned, say the defense lawyer can make a submission, say I want to let them try my client by a judge alone or trial by. Let just left open that way. If it be that way, it go fine. It will help the criminal justice system. But if then left out in the hands of a judge alone, considering the toxicity of our political system in Sierra Leone, it not go born good picking because it will be retributive justice when this one then come on power, when the other one then come, then it will be turn and give waiting the other one then we don't do because then being that the president now they select now they appoint the chief justice so only and solely and I they appoint judges and justice of the Superior Court of the Supreme Court, they can do anything because like now the US here, we get conservative judges, we get liberal judges. So that's something like that they go be in Sierra Leone. You get judges or judges that we go favor the red party APC, and you go get judges that we go favor the green party. So when the Chief Justice they allocate cases them, especially politically motivated cases, if the case now against this party we know they in power, it will definitely give them to the one way say the judge where they know say the favor the party. So we just prevail on the president. Let it take a second look at the act. Let it not sign them and send and go back. Let it just put and they say either trial by judge or judge alone or trial or a jury. So let it be that way. So up to the
I can suggest something even better. This part two would look at what they say the High Court of Justice shall be duly constituted as the case may be. And then they say A, by any one judge thereof, or by any one judge thereof and a jury. First of all, the draftsmanship is just what leads to confusion. Under dual,
Right, because
strict
that's a petition.
no, but not only that, under strict
Repetition.
constitutional construction is poor draftsmanship. First of all, I think they don't need an A and a B in this respect because what will have been wrong if they say, as the case may be, by any one judge, and watching at the meaning of thereof. Why take the thereof and say and a jury? There will be no ambiguity by a judge and a jury. Then you follow it up by saying, unless the defendant knowingly waives his right to a jury trial, then that becomes procedural. Well, how does he waive his right knowingly? You see, then go get a format where then go follow for make sure say the defendant knows say where they waiving right, it they waive unknowingly. Then they go examine and the court will examine like now. The judge will ask you, is your name such and such and such? You say yes. Are you now under the influence of drug, alcohol, or any intoxicating substance? You can say yes or no. Then the judge will even ask you questions like, have you been promised anything in exchange for you waiving your rights to a jury trial? Have you been promised anything? Have you been threatened? All of that I want on the record. But the way they write this law, if you read them, I don't even understand what it means by any one judge. Well, I don't know if there's a difference between by any judge or any one judge, and the word thereof is totally unnecessary. Then again, just to put legal terminology, they were not necessary because it can be by any judge and a jury. The thereof doesn't mean anything. What does it mean? You see? So these are the old British craftsmanship way back when lawyers didn't go to college, then learn their writing through just experience. But nowadays, in fact, when I was in law school, I used to have a criminal law professor, Professor Washington, who said there is no such thing as legal writing. He said just learn how to write correct English. And I agree with that because this word thereof, what does it add to the meaning? If it is not there, does it say? Is it not saying the same thing? You see, these are some of the things, and then in constitutional law, ambiguity, what they can also call vagueness, is a valid defense because a lawyer can go to court and say, "Hey, we can't prepare a case adequately because the statute is ambiguous. It's not clear. It's vague. Give me client a sufficient understanding of what he's being charged with." And judges dismiss cases strictly on that grounding. So I'm just simply saying, but I still disagree with the gentleman who called because he said the only changes in the law, then change the jury system from 12 jurors to 10. Well, first of all, it will make no sense to me. I would like to understand the genius in reducing it from 12 to 10.
That's that even is wrong, Mr. Shillon.
Yeah.
If you want
So
to constitute a proper jury, it has to be an odd number for voting sake. Not an even number
you,
they constitute a jury
but what
on.
difference will it make if you reduce them from 12 to 10 is what I don't understand. It according to him, he said that's what the law is. Then just they only reduce the number of jurors, you know, for compose a jury. So I don't understand why they will reduce them from 12 to 10. What's the idea behind that? But I don't think that's the entire law because they say it is abolished. They say it is abolished. Now the issue about because Mr. The gentleman who just called, his name just escaped me. Uh, it asked if he didn't have the Constitution. The right to a jury trial, as it is in the United States, which is a constitutional right, it's a fundamental right. It is not so written that we own system, Sierra Leone. The system, by statute, give people a right. I think even by maybe the Constitution give you a right to a jury trial, but it's not so worded
It's
as to
not
make you
worded like
feel,
that, but it's
yeah,
embedded.
yeah.
It's
And then,
embedded in chapter 3 of the Constitution.
okay, because I once asked a
It's
lawyer,
embedded
I
under
said, why
the
is that?
recognition and protection of fundamental human rights and freedoms of the individual. 15 and 16. If you read them properly and understand the language, that right is embedded. I
Okay,
make her
and that's the
say,
way it should
let
be.
them go, then get a legal mind for interpret that part they properly. Then go see say, if they abolish the jury system, they don't go against that right in the Constitution. Because
Exactly, because
that's an entrenched part of the Constitution.
because you are right, Mr. Jamboria, because any treaties where we are participant of, what we participate in, that internationally drawn treaty, they become part and parcel of we law.
As
So we
long as
cannot be
it has
so,
been ratified by the Parliament.
yes, Parliament, yeah.
Those that are not ratified are not law. Those that have been ratified automatically don't be part of the national law. And the Universal Declaration on Human Rights was ratified in 1964 by the Parliament of Sierra Leone. So every
There we go.
article in it is applicable as law in Sierra Leone. Article 7, let them read them properly. Let them read them properly. Thank God I went to do social justice under ILO. Then here we know them. And they misuse the laws in Sierra Leone too much because of emotions, political emotions. It's time we stop that. Sierra Leone needs stability. Let them read
But
chapter 3. Let them read the Universal Declaration on Human Rights, Article 7. Let it be properly interpreted by competent legal minds. Then go see say that trial by jury is embedded there. It's a fundamental human right.
okay, because the constitution, because we see from we on control room, then they show what the gentleman posted. I still take issue with the fact that that does not entail the entire is very more involving than what he posts, saying that the essence of the Lord I want it, you know. Uh,
Chapter 3, now the fundamental human rights day.
no, you know, in post say then change the jury from composition from 12 to 10. That's all the law is.
If it was not made public until he came with it, then it's the responsibility of the government. The reason you make them say then they gazette laws and things like that, now for inform the public. But even before the law it has passed through the readings in parliament, it is normal and ethical for make them get public debates and information on this. As the speaker, Mr. Vandy, rightly say, Now the duty of the members of parliament for go discuss the issues with them people. But they're not they do them.
Okay.
Why make I say
No,
with parliament not mature?
okay, we get it, because I think we'll get a posting from we on control room. This section 39, where the gentleman keep referring to, we'll talk about the mode of trial and under this 2024 Act. It's a trial by judge with the aid of accessories. God alone knows what that means. I don't know.
Assessor.
Assessors. I don't know what that means. Then at section 140. Section 141 say trial by judge alone at instance of Attorney General and Minister of Justice. You know, at
Even
well, if I'm not
141 is political.
well, yeah, but
It's
see,
political.
that should be, but that should be unconstitutional because the person going to trial has a constitutionally protected right. The Attorney General or the Minister of Justice
They
should
should
never
insist
ever
on
have the
what type
power.
of trial.
Well, it
No,
should never ever have the power to waive that person then your rights to it. You see, this is a problem.
no,
Oh, we get
no, and
Mr.
not
Leone.
get power there. Now
Section
the person
141,
for waive the power.
exactly. And again, I keep repeating the phrase. And the person for waive the power, if I waive that right today knowingly, intelligently, and the
Yeah,
only way the court get for examine that person day, even if he assert that in court, say I want to be tried by a judge alone, the judge should be responsible in examining this person by asking him series of questions to be convinced that he knows what he's doing. He knows what the waiver entail because it's a constitutionally protected right. Section 141 should be completely out of the question. It should not exist. The Attorney
exactly.
General and the Minister of Justice should not be the one exercising somebody in constitutional right. But
It's
these are some of the errors they
political.
already
It's a
made.
political statement.
You
It's
see?
a political statement. Because Attorney General and Minister of Justice is a political person.
So the laws are kind of conflicting. Then I think you get one section where they talk about the court may order the discharge of a jury or assessors. Well, uh, so I think what has happened here, we just copy from some other country, from some other system. We not try for uh, 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 uh,
I'll
custom
give
make.
you I'll give you a quote on that, Mr. Shillon. They say confidence is ignorance. If you are feeling cocky, it's because there is something you don't know. Confidence is
That,
ignorance. If you are feeling cocky, it's because there is something you don't know. And when you look at them laws here, you dey see the input of cockiness because they are not properly researched. If they were properly researched before they are drafted, some of them are not go dede.
exactly, because
Even a
some of them are,
schoolboy can question some of these things.
yeah, like section
I say
141 was
cockiness.
just
Now we dey, now we know. So what you do? Now the next court, nobody not get nothing you go say. Tomorrow I go come back and hunt you. FM Mina made a law in 1971 we hunt them. S.I. Kuruma assisted in creating a system that haunted him. And people then think. If we not think, history will continue to repeat itself in Sierra Leone.
I agree. But please, really strongly encourage others to call. Let me see if I can take one more call. Hello, caller. What's your name? Where side you call from?
Yeah, the name Alpha Cisse, I call from Alaska.
Hey, Mr. Sisi, welcome. Go ahead.
Yes, I just listened to now about this jury trial, or no jury trial.
Yeah.
Waiting would I don't read so, and waiting that call away say he don't read. Now the same thing, Mr. Silon. It's just waiting me the experience and waiting me the notice. Right now na salon. If you na hardcore SLPP supporter or hardcore APC supporter, una they read the same thing, but una they see it differently. Now that mean they know this. This na
Okay.
back. Wetin that man they say you don't read it. Wetin una don't read are the same thing. It's just a different interpretation. Now we might, right? So now don't forget about the constitution for a minute and the laws and whether they amend laws and stuff like that in a salon. But we don't see people that they boycott parliament or boycott the law. If they need money, then go straight in a bank. Take money, say in transportation. Woman back can go there, take money, then travel without parliament in consent. All them things are then are the law. So not the law problem we get in a salon or the constitution or repeal or change laws. Now waiting we they do actually for able for follow the law or the rules and regulations of constitution. Now it matter. Well, I'll give you an example which are they talk by that. So now they people that they talk about see something, say something. We get Victor Ford and now where they not just see something, say something, then don't do something and say something. They're still there in Sierra Leone walking freely. This now that's here we talk about, not to appeal. We're just wasting our time for debate. Oh, not to so the constitution say when they misinform. No, not to misinform. The same thing when I don't read so. Now the same thing when that man read. But like I said, the understanding right now about anything at salon, if you're an SLPP supporter, you they read the same thing where that other person they read, but you they see it differently, that other person they see it differently. Now the problem, Mr. Still, now with the face. So I rest my case. That's my own contribution that.
Well, thank you so much. And the way you solve that problem there, now that make the court exist when several or more than one interpretation can be drawn from a law where parliament passed, where the president signed, waiting the court now then now then responsibility now then for interpret the law so we all go get one understanding because the law it's not supposed to have more than one meaning. So it get a lot for do with waiting enough of depend on way understanding. Everybody understanding of what the law is, it should be clear. So usually if it is vague, a bad law, and if you charge somebody under that law, the point then go find the person not guilty, a judge could dismiss the case because now, as a matter of law, you don't need a jury trial for that because the judge would dismiss the case as a matter of law. But let me take one quick call again. Hello, caller. What's your name? Where you call from?
Now me again for them. I just want this short one, just a warning. Say, do ya now? This we talk about fake news. I want to be careful. Then people are where they come with them thing they are so. Let us friend we for verify them. Go to gather. If the government, if these things they have to correct something, if we don't counter them from salon, because now from salon, anything they are come out. May we
Yeah.
wait out there abroad they are so. We dey just sit down. So it seems that other thing with the right. You see the language self. It's suspicious. Despite the tautology, even the language. I mean, from Parliament, and obviously they go from Constitution. They don't go put that kind of writing, that kind of language. So I just want make una try for verify these things. They wouldn't talk. Maybe now for try for inside this platform for try for suit the situation. I mean, may it look calm, only because it's unbelievable. Instead of them for go, tell them, make the guys and do the right thing. No, we get peace and development and let people and pocket them and they be small. They will not do it. Then they sit down. I always talk and say, I'm very disappointed at the diasporans more than the people in back home because it's easy for your party for them in power. Just make sure see the economic lives of the people become better. Than it is done. I mean, you dey get water, you dey get all the liberties them of life. You want go take motor today, you go take them. Then you know go want transfer that thing there to the people the way they put for the party for the party kind of power. So now that's my one for make una try verify this document. The document there, which some people and they put saying that so thing be We the one within a salon wait for defend and not you defend them. I'm very it's very suspicious to me. Nothing I want to add on this issue. Thank you.
Well, that make a lot of sense, and we'll go endeavor. But we do know, as a matter of fact, we'll get the official text again of the act. Oh, hello? But we do know, as a matter of fact, that law was indeed passed uh, now parliament where the president gave us sign, where they asked for the abolition, then say, abolition of the jury system. So we go try to get the official gazetted maybe documents for talk about that. But that's what we know. So that particular section there, I'm trying to, I don't want to be firm on it, that what was sent to us or what we're quoting is the new law. You know, say the bill was dated January 11th, 2024, the Criminal Procedure Act 2024, Part 1. Then say in Gazette and a volume, whatever volume that is. So we try to take a
CX.
look, yeah, CLXV, you know. So, but we just
We go
want to let
look at the
people know.
document. We go look am. Well, my point of contention is, if this is the bill that has been passed before Parliament, and there are people who have come on social media, Twitter, etc., for comment about them. If the government was proactive, they would have come out with a statement saying, no, this is not what it is. This is how it is. Go and use this reference to verify. With this impunity mentality, not agree. I left them normal, let them talk their own. Who don't pass with law. You cannot treat a nation with contempt where they rule the nation. We go tell with politicians then that. Let them stop that. They are servants to the people, not masters. When you are ruling a nation, extend discrepancies here, extend misunderstanding here. Be prepared to address them for promote and enhance peace and stability in the country. Not use
Correct,
them
correct.
for create more unrest. You are not a demigod to the people. You are there to serve. And whatever happens, you live there one day. If you not accommodate by election taking you out, you go accommodate by natural death. And when that happens, you would have left a legacy for your children to correct. How long will they repeat this one grey history? Will this come out? Then the next one will come. Now for can fet the past government. I make with the Eleka with this so 63 years after independence. It's here for stop now. And if we stop beginning with responsible governance, whatever comes from the government has to be policies and laws that are not against any sector of the society. Because governance itself has to be inclusive. You will read the new British Prime Minister in speech. He made it clear. He thanked the one that will vote for him. At the same time, he thanked the one that will not vote for him. He say, I'm Prime Minister of everybody. What's the attitude for governors? Not of what can say now we turn for it, bullet for bullet. Now, mature statements then coming from responsible public officials. Very immature. And now this some of you get for be concerned about from now onwards. Governance has to go with certain levels of maturity, especially on the ethical and moral front. What you need for the consider the discuss then here? We need for consider the discuss here. What in our opinion about how for make salon go before? But all the time they come for consider for discuss the problem where a bunch of people they cause for the country. Help we go before. Be honest with ourselves. We should not be coming here to discuss problems created We should be coming here to discuss recommendations. We want views, informed views about what for do let we country rise from Usaidi. Now all man they all about tripartite, MCC money attached to tripartite. Do
Okay.
we even need MCC money? Let we ask this question. If we are not a people causing trouble for ourselves, if we are not a people doing self-sabotage, we call on self-politics, we don't need
o-
MCC money. Sierra
Okay.
Leoneans in the diaspora alone can agree, say, okay, they buy treasury bonds from the government of Sierra Leone. We agree, say, we're going to give the equivalent of $100 per month. Over the year, we put $1,200. If 1 million Sierra Leoneans put that money, every year we are collecting $1.2 billion. It can go a long way to begin to develop Sierra Leone. But because we know they think, also they can't sit on the island, hey, Bio don't do so, Samoa don't do so, Nest don't do so. Hey, if we say Sierra Leone is bigger than all of us, we should begin to think that way, not talk that way. I'm saying this especially to those in government. Think that way, build trust in society. Then you'll see wonders happen. We will come to assist you.
Well, one thing I want for points to with folks then will listen and will look. It appears as if the posting we'll get now, control room post this one. They need for read section 40, which is so many see what understanding do they get out of it. The thing reads a person charged with a crime or a criminal offense at the High
Criminal
Court.
offense at the High Court, other than murder or treason, may at any time of being committed or referred for trial, or at any time thereafter, up to 2 clear days, at least before the trial of such person, whether he had previously elected otherwise or not, elect to be tried by a judge with the aid of assessors, and if a person shall so elect, he shall be tried by a judge with the aid of assessors instead of tried by a judge and jury. This sentence honestly not make sense to me, Mr. Shim.
This is,
Number one, it's too
you
long.
see, Paul,
Number
you see the
one, it's
draft
too long. Number two, it is an overloaded lexon. It's an
well,
overloaded lexon.
but don't you read it as that if you are charged with murder or treason, you are not entitled to jury trial? Why? If you are falsely accused of overthrowing a
I make the
government,
sentence
or,
unnecessarily long for
well,
confuse the readers.
any lawyer, the first thing he could file a motion to strike. The judge could declare the law so vague that it is not possible for apply them sensibly. And if someone is charged under that crime day, then the judge could dismiss the case against the person because this is as
Yeah,
vague and as dense as a case can be. You know.
the sentence too unnecessarily long. So it don't make the whole thing vague. You not go take 4, 5 different idea, put on one place.
Well, you can't make any sense out of what you just read, so you can't make much sense out of it
Honest,
at all. And, and then why are you going to exempt murder and treason? So if a person is fair, if a person is charged with murder, that he should be tried by a judge alone, and not forget the right for be charged by his peers. Are we going to abolish that right today?
or a
So
person commit treason if you be charged by a judge alone.
yeah, and what we
Because now
know
that
already,
imply.
yeah, and what we know say treason, by all indication, that in our cases the way government get interest in the outcome. So you could think
Yeah,
so that
yeah.
in that side you could protect the defendant or the accused even more. Instead, when they expose the defendant even more and say, not even worry because we're not give you trial now. What you would think say you're guilty of now, it could be.
And
You
how
see?
can we prove the innocence of the person?
Well, no,
Somebody may
according
be
to the way,
accused of treason. Wait until guilty of. In lawyer, he versus the judge and the prosecutors. So there is no third party in the court, which may be the juror. We go look and say, okay, we don't hear the defense, we don't hear the prosecution. This is how we see it. Now, if you are going to charge somebody with treason, with juror or not they, that means the ratio is 2-1. The person and the lawyer versus the judge and the prosecutor. Because the judge is always going to be on the side of the government.
For sure. Usually.
Mathematically, the ratio is 2-1, and that makes it unfair. It goes against the fundamental human rights. I can make that reference, let them look chapter 3, and let them look at the Universal Declaration on Human Rights, Article 7. I'm not a lawyer, but I think I'm comfortable with certain aspects of law as a trained trade unionist and somebody for social justice. Nobody know the bend the law, it's a rapper and I'm head.
Okay. We got some more callers. Hello, caller. What's your name and where you call from?
Hello, Mr. Shilon. This is now Omar the call.
Mr. Omar, thanks for calling.
Good evening at the studio. And
welcome.
First of all, let me just give me a contribution. We need two things in Sierra Leone when it comes in terms of justice. Of course, major cases, we need jurors. And minor cases, they not get anything for doing a court. You know, cases like traffic offense and so on. Therefore, just find people make sure say they enforce the fine, and make sure say people pay the fine. You know, but when it comes in terms of the juror, in fact, let me tell you something. Now, somebody commit murder, if I need them. Recently, something happened in Europe, in Germany, for instance. A lady born, it threw the picking out of the window. You know, if na then kind thing and they happen at Sierra Leone straight away, I think say then the adults if you go reach na court, what then do then through juror and then find them guilty. And could you imagine sees that happen? Now recently then find her guilty. And then the other one up again at Italy, where the boy brother fed him behead him brother. It's not na balcony, he kick him brother head. Where he cuts the head, it's not a balcony, he kick her on the streets. But in the juror, because most of, in fact, when I talk in terms of where murder case, most of them can be now people can get mental problem because for let you get that mind for kill somebody first, it go be don't don't get that mental problem. We go make that, and then people in the before even though they're guilty, but I feel say now then said in the we need jurors more. Then Mr. Shilon talks on TG where he say it come some of treason na case the government get interest. So I feel say the juror system will for try for maintain and I will just strengthen or make sure say it serve in purpose. Mr. Jambura talk something where they talk about contribution. You know, first of all, before they talk about contribution, Mr. Jambura, the government, just like what you say, the government for try for win the people in trust. You know, but the trust, you know, if you trust, yes, it can happen. For instance, Switzerland, last month, almost 2 months ago, then get a problem when a flood, a mudslide and flood at the same time. Could you imagine? It's not a governmental. This now waiting the people in the put within the contribution individually. Then they raise every day 1 million. Every day. In fact, sometimes 2 days ago, they raised over $1 million per day. You know, just imagine this one to this one. People we can say, no, hey, I get €100. Hey, I get €50. 100 francs. I get 50 francs. Before you remember, that money don't reach to that amount. Every day that in the race. Wait a minute to do that. Now, because of the government give people in trust, you know, and then the people don't say, if they do it go reach Uda then smart Uda there if for serve. So na that position for now for it. Me, I know they say look, man, no contribute to, but at least now we know say if we contribute with money or if we put money on national purpose, let it serve in purpose. If that happen, we already are so to God. If we see say that way serious, me say Kisido Asia, but they do an app ordinary program or they see na Facebook. Would they contribute them $100, they contribute them $50. Whatever if you know see a good purpose, when a national purpose. But the government then for do more and we need more from them. Thank you very much.
All right, sir. We'll go try to take one more call from. We'll go try to take one more call. Then we go do whatever closing we get for do. So time goes fast when you're having fun. I think we'll get some fun on this jury trial discussion or abolition. So hello caller, what's your name? Who's the call from? Hello? Hello caller? Hello caller. Well, I think we may have lost the one call we want for take. Yeah. So well, going back, we managed for again post waiting we see as what we just analyzed just now as some gobbledygook craftsmanship of the new law where you can't get any understanding of what they are talking about. But they need to go back and look at Section 141. The Attorney General and the Ministry of Justice not forget the right for waive anybody in your own trial. They can get the right for waive the government's case. You can do do that for the government because you're the spokesperson, but not an individual. So Section 141 is definitely inappropriately placed. So then the Section 140 which seem to be applicable seem like by implication they take away the word jury. Now then they use the word accessories or assessors. Whatever that means, it should be
What
clearly
does
explained.
assessor mean?
Yeah. Whatever that means,
What
we
does
should
assessor
know.
mean?
It beats me. Why is it a better word than jury? So these are all the confusion, the draftsmanship, and maybe sometimes by way of standard where you learn too much book. I mean that can happen. You go get for right for the rest of who we can't understand what you write. Maybe that's the point. But again, this section 140, Mr. Jamboria, as you read, and people need for take a look at it. It is just so confusing. It doesn't make any sense.
Yeah,
But by
they
implication,
say in common law, assessors are usually non-lawyers who sit together with a judge to provide either expert advice, such as on a maritime matter.
well, why is that going to replace the jury system? I mean, what
I
you
don't
see,
know. I don't know.
Americans then say if it ain't broke, then the part one or
Don't
the
fix it.
don't fix it. So why are we trying to fix something we're not broke? That is I don't
Who are these
understand.
assessors? What qualifies them to sit with a judge when they are non-lawyers?
And if they do, are they jury of your? Are they assessors of your peers? That people where you will get common worldly social
Isn't that
experience with?
politicizing? Isn't that politicizing the judiciary? Because these assessors are all going to be politically appointed.
Of course, that's what will
It's
happen.
clear.
You see, and
Where are
so
we headed for?
with corrupt intent, not because they want to improve the system, because they want skew the system in favor of the government,
It's
which
part
is all
of
the
the state
consistent.
capture, Mr. Shillong.
Yeah, but
It's
it's not
part
going
of
to
the state
benefit them.
capture.
At the end of the day, the very one that would promote this law, they will become victim of it. I don't know whether or not they
Yes,
understand that.
exactly. When Albert Magaibin passed that Public Order Act 1965, not of the fet with today.
Yeah,
Albert Magaide again in Odongo.
it don't affect generation upon generations. We see that, but we're not the land. We keep, everything is politically motivated. You can tell, say, this jury thing, there is a thing behind it. Whatever idea the previous government may have had for wanting it so necessarily. I think it makes sense to the current government, so they want to make them now the law. Because I tell you, I talk with
And
the
it's
top
fine
notch.
for them.
Yeah, I talked with the top notch previous government official who said they were contemplating that. So, and I asked her why. I say I don't think a good idea, but the system needs so much changes. Then are the least thing they should be concerned about. If unless they get away, they want for twist them in a way for oppressed political expression. That's all. Otherwise, if they mean well, they
And
shouldn't even be touching the
in the
jury
first
trial.
place, Mr. Shillon, a society in the present state of Sierra Leone, with the kind of political economy that we have, it will be in the best interest of the country for make we concern ourselves more about economic and social safety policies wey go improve the lives of the people than making bogus laws. Number one, when you begin imprison people too much, now expenses on the state. It costs less when you have less criminals in society. The less criminals you have in society, the more profits the state they make, because those people, if they are engaged in some activities that they bring revenue to the state, now more money the state they make. But if
Yep.
you get 8 million people, you create conditions for make 6 million they suffer, then and the 6 million, 4 million turn criminal, go jail they all. Laws you that the losses. The state the losses because you get for feed them and do other things for them. And if they make them say some man go look say, all right, la they prison now. He better enter they eat one mondores every day. Our leaders have to begin to think. This cockiness about we know, that we didn't have power, let them put them aside. Make Sierra Leone. Sierra Leone has so much that if we're ready for Mecca, everybody go profit in that country. Then Lord, yeah, we don't need them. We need to come with policies we go enhance economic and social change in the country. We go improve on consumption. We go improve on wages. Nobody is talking about those. But they would prefer to make all the laws, steal all the state money, then build castles and make the castles into prisons. Because when you build a house, you put high wall, you put metal na gate, metal na window, put camera here and there. It's as good as a prison.
Mm-hmm.
Are we really thinking in Sierra Leone? Honestly, are we really thinking? It's time we begin to think. Oh, otherwise, technology they move at a pace where AI go come, it take over the world, then we go left suffer. Because when technology take over, people without skills now then get for suffer.
Yep.
Honestly.
That is so true.
Why they think in that direction? We they think about how to create more chaos for a few people for enjoy. Let's keep enjoying. One day that enjoyment go full up on a belly take come on at the nose.
Well, all good things must come to an end. We even want to talk about tripartite, the MCC compact. We always can get overloaded, but we are better off being overloaded than underloaded. So, but we still go deal with the tripartite and the MCC because not only is it a trending thing, na matter of, or there are matters of great importance we will need for touch uh, up with and consistent with we purpose of doing this show for expose and educate and allow others to contribute ideas. We want for impact ideas, we want for contribute, we want to give people in the freedom for express themselves and to be able to make contribution. So because of that, we greatly appreciate when I would listen, when I would call, when I would find the discussion fascinating. Sorry, we did have some callers online. We didn't get to. Some of them um, got frustrated and hung up. So we can always try for God against that, but it's almost impossible. I can always worry about the fourth or fifth caller on the line or beyond. Because if you're number six, number seven, you got a long time to wait or to hold because we give everybody 3 minutes. We're sorry, but please don't be despondent, don't be discouraged. Keep listening to us, keep calling. We thank you so much. But let me turn it over for Mikos for making your own closing statement. But I've made mine already. So until next week, me and we will see again and talk again.
Please humble them. We will come now, we they go. And so shall Maxwell be the say. We tell una thank you for una listen to we. And we not go tire. We continue side on reach so now. I think now then kind advocacy here we need. Let all man wake up, let we know what we need for no. Let we do things right for the benefit of everybody. As one caller been say, let we try for do thing go build trust. Trust for build them. Sierra Leone will become the greatest nation in Africa. But if we say no, they pan this fat kuku muku business, eh, they go triangle for picking them who don't die go. And some of you don't want that. Now I make who they talk. We not they talk because we favor political party. We not they talk because we favor political persons. We they talk because we favor Sierra Leone. Sierra Leone is bigger than all of us. Let us think, act, and do things we go make Sierra Leone what it for be. Una thank you. We go see back next week. Natata.
And as always, Mr. Jambaria, on the air, we are so grateful to you for your contribution, your participation. So thank you very much, sir.
Thank you, sir. We thank God for everything.